Welcome to today's class, our class of company law. And we are at the second topic about formation of companies. Formation of companies. Formation of companies. We are done with nature, purpose, classification of companies. We are done with that. Yes. And our today's topic shall be nature. Shall be the formation of companies. Sorry for that. And one thing that you should know about in this topic is somebody called promoter. And a promoter is any person who undertakes in the formation of a company. Are you together? A promoter is any person whom undertakes in the formation of a company. That's a promoter. Actually, that's the definition of a promoter. That's a promoter is any person who undertakes in the formation of a company. Then that process of forming a company is regarded as promotion. Are you together? That process of forming a company is regarded as promotion. And the person who forms the company is known as the promoter. Are you together? Yes. And there is a process that usually follow in the formation of the companies, the process of forming a company, the process of forming a company. There is a process that usually is followed, or the company act, or in short, the company law outlines in the formation of companies. And number one is reservation of a name. One is reservation of the company's name. You ought to have a name of the company that you are in the process of promotion. Two, assembly of resources. Number two, we have assembly of resources, assembly of resources. Are you together? Yes. Two, we have assembly of resources. Three, preparation of constitutive documents. Preparation of constitutive documents. Somebody is asking me, my first time, what's the name of the teacher? I'm Simon. I'm Simon. Yes. We have said preparation of constitutive document. Preparation of constitutive documents. And which are these constitutive documents, or what we are talking about here are articles of association as well as memorandum of association. Are together? Then the fourth step is called presentation of constitutive document. Presentation of constitutive documents. Presentation of constitutive document. Presentation of the constitutive documents. Presentation of constitutive documents. Then the fifth one is payment of stamp duty. Payment of stamp duty. Payment of stamp duty. Payment of the stamp duty. Payment of the stamp duty. And lastly, number 6 is registration and issuance of certificate of incorporation. Registration and issuance of certificate of incorporation. Registration and issuance of certificate of incorporation. Certificate of incorporation. In the examination, don't use the initials. Yes, I'm just doing it so as we can Move fast. Certificate of incorporation. Certificate of. This is the process of forming a company. That's number one, reservation of a name. Number two, you assemble the resources. You prepare the constitutive documents. Number four, you present the constitutive documents. Number five, the payment of the stamp duty. And lastly, number six, you have the registration and issuance of certificate of incorporation. And when we are talking about the reservation of a company name, it's the duty of the promoter to come up with a desirable name in the concept or in the context or in the perspective of the registrar of companies. Meaning, when I'm saying that it is a desirable name, meaning that there are those names which are undesirable. Are you together? Like for instance, you cannot name a company which are too similar alike with an already existing legal entity. Are you together? You cannot also register a company names which is referring to the head of state or the royal family, like for instance, Uhuru Kenyatta Limited or Kibaki or Ruto or Museveni Shop Limited or Queen Elizabeth, whatever. Are you together? You cannot name a company name which is similar to a government department or a government agent. Like for instance, the Ministry of Agriculture Limited. Are you together? You cannot as well name a name of a company which is connoting immoral behaviors or which is connoting immoral issues. Are you together? Another thing is that you cannot name a company a name of an international organization whereby Kenya is a member. Like for instance, you cannot name a company by the name United Nations Limited. Are you together? Let's talk about that, or let's write about that. Let's talk reservation of a name. Reservation of a name. Reservation of a name. But you are understanding that. Are we together? Yes. Before you write something, I need you understand such that when you are writing it now, you're just affirming of what you already know. Are you together? Yes. And so you like the promoter after identifying name. The promoter after identifying name of the proposed company, the promoter after identifying name of the proposed company must search at the company's registry to check if the name is desirable for registration. I've said the promoter after identifying name of the proposed company must search at the company's registry to check if the name is desirable for registration. Are you together? Yes. The promoter after identifying name of the proposed company must search at the company's registry to check if the name is desirable for registration. You say the following names are undesirable. 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 Number one, names similar with names of existing companies. Names similar with names of existing companies or other legal entities. In short, names which are too alike. Like in Kenya, in the telecommunication, we have Safaricom. Is it? Huh? Cannot call your name, your company now, Safaricom. Is it? Cannot call your name Safaricom because they are too alike. Is it? They are too alike. and if it's the difference of R and R. You see? Yes. Two is names which are misleading. Names which are misleading. Names which are misleading as to the nature of the company's area of business. Names which are misleading as to the nature of the company area of business or geographical location of operation. Location of operation. Like for instance, yes, names which are misleading as to the nature. Names which are misleading as to the nature of the company area of business or geographical location of its operation. Are we together now? Yes. What am I saying? Like for instance, you call your company ABC East Africa Limited. Is it? But this ABC here, ABC Limited, it just operates at Mufagano Street only, but you're calling it East Africa. You see, my friend, that's an undesirable name. Next is names that connote immoral activities. More names that connote immoral activities. Names that connote immoral activities. Names that connote immoral activities. Next is names associated with head of state and loyal families. Names associated with head of states and loyal families. Names associated with head of states and loyal families. Next is names similar to government departments or county government. Names similar to county government and government departments. Names similar to government departments or county governments. Next one, we have names associated with our independence. Names associated with our independence. Names associated with our independence. Like for instance, you cannot call your company Madaraka Day. Madaraka Day live right together. Yes. Names associated with our independence. The next one is names similar to international organization, which Kenya is a member. Names similar to international organization in which Kenya is a member. E.g., or for instance, you cannot call your name of the company United Nations or UN Limited, because Kenya is still a member. They are all WHO or others, or UNESCO and others. Next one, they are names similar to churches or a holy place of worship. Names similar to churches or a holy place of worship. That's an undesirable name. Like for instance, we have various churches. We have different churches in Kenya, whereby you can say AIPCA. You know it? That is African Independent Pentecostal Church of Africa. You cannot call your company AIPCA Limited. Or one of the famous is All Saint Cathedral. You see? All Saint Cathedral Limited. Or ACK PLC. You cannot call the company name such. Another one is names of individual who are not directors of the company. Names of individual who are not directors of the company. Names of individual who are not the directors of the company. Like for instance, you're calling your company Simon Limited. But Simon is not one of the directors of the company. Are you together? Yes. Next one is names promoting violence. Names promoting violence. Names promoting violence. Names promoting violence. Next one, or the last one, we have initials are not accepted. Say initials are not accepted. Initials are not accepted. Initials are not accepted unless their full meaning. Initials are not accepted unless their full meaning are written out. Initials are not accepted unless their full meaning is or are written out. All together. Yes. Like for instance, if you see actually all of the companies or all of the organizations, even UN, you shall find that yes, it's written UN, but there down, there is what? United Nations, is it? Like WHO, you will see there down, it's written World Health Organization. KCB, is it? Kenya Commercial Bank, Apochini, is it? Yes. You can proceed on to, I think this direct, or we can write a sentence about the assembly of resources. Yes, assembly of resources, 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 assembly of resources. Remember now, in here, remember that the company is yet to exist. Are you together? So the person who is doing this task here, the person who is doing this task here is who? The promoter. Because we have said that the promoter is the person who undertakes in the formation of the company in a process called promotion. So it's the duty of the promoter to make sure that the resources such as capital and human resource have been catered for or have been achieved so as the commencement of the business can be appropriate. Are you together? Yes, let's write something. We say, the promoters have a duty. The promoters have a duty. The promoters have a duty. The promoters have a duty to assemble various resources. The promoters have a duty to assemble various resources, which may include capital, which may include capital, which may include capital, comma, human resource, to enable the company to be operational after registration, which may include capital, human resource, to enable the company to be operational after registration. To enable the company to be operational after registration. Is that understandable? We are moving together. Is it? Let's talk about preparation of constitutive documents. Here we can list the constitutive documents right together. Remember, we have the different types of the constitutive documents that we really need for the company to be in operation. So you say some of the constitutive documents include, some of the constitutive key documents include, some of the key constitutive documents include, number one, articles of association, articles of association. Two, memorandum of association, memorandum of association. 3, you say statement of capital and initial shareholding, statement of capital and initial shareholding for companies with share capital. Statement of capital and initial shareholding for companies with share capital. Are you together? Statement of capital and initial shareholding for companies with a share capital. The next one is statement of companies' proposed officers. Statement of the company's proposed officers for companies limited by guarantee. For companies limited by guarantee. For companies, statement of companies' proposed officers for companies limited by guarantee. For companies limited by guarantee. Lastly, we have written undertakings of the directors. Written undertakings of the director. Written undertaking of the directors of the company. Written undertakings of the directors of the company, including the consent in writing. Written undertakings of the directors of the company, including the consent in writing. Are you together? And those are the constitutive documents. I've said last 3 is written undertakings of the directors of the company, including the consent in writing. Consent. Consent, it's like approval, is it? Yes, or I am agreeing of me being the director of this company, is it? Yes. Yes, you're excused. You can list them as the YAL because you cannot pay the stamp duty for the online student. I am one of our good student here is asking whether is it good to arrange them as they are. I think it can be okay because now you cannot assemble the resources of what you don't know. Is it? You cannot present the constitutive document if you have not prepared. Is it? And as well, you cannot pay the stamp duty of what you have not already prepared. You see? Neither can you be registered of something that you don't know. Is it? Yes. But it's so direct. See? Yes, yes. But when you read 1, 2, 3 times, you get to understand. Especially for us, we usually read 5 or 6 times or 7 times. Me, personally, for me to understand, is it? Yes, yes. The process ought to follow, is it? Yes, yes. Have I answered your question? I think I have. Thank you. Is there a difference between a promoter and a founder? The one and the same thing. But in company law, they are not called the founders. They are called promoters because they promote. Yes. Are you together? Yes. So the next thing that we shall tackle is certificate of incorporation. Certificate of incorporation. Certificate of incorporation. No. Oh, the others are just direct, is it? After we have attained here now, you just present it to the registrar. The payment of the stamp duty is to the registrar, and the registration and issuance of certificate of incorporation is by the registrar. The other ones are so direct. So we can just leave it at that. So we can go to something that shall be, probably they shall be it shall be examined, called certificate of incorporation. Are you together? Yes. And when I'm talking about the certificate of incorporation, these are documents that is given by the registrar upon the date of incorporation of a company. Sasa. And this is like the birth certificate of who? Of the company. So in short, it will establish a body corporate. Remember we said that for a company, it's regarded as a person, but it's an artificial person. That's why we said some of the consequences of incorporation includes: one, yes, can sue and be sued. Two, even for our online student, Kaitre. Two, yes, contractual capacity. Three, yes. Three, yes, common seal, that's true. Watu wanaiva. Yes. Thank you, can own property. Watu wanaungua huku. Yes, next. Unaungua hata before examination. I personally love that. Perpetual succession, that is null Whitney. Independent management, sure. On property, sure. Legal person, that's good. So we have said now, upon now the incorporation now, this is like what is given. So we can just write three sentences onto that. Number one is that these are documents issued by a registrar on the date of incorporation. This is a document that is issued by the registrar upon incorporation. These are document issued by a registrar on the date of incorporation. Is a document issued by the registrar on the date of incorporation. Two, you say it is the company's birth certificate. It's the company's birth certificate. It's the company's birth certificate. It's the company's birth certificate. Next, you say that it establishes a body corporate. It establishes a body corporate. And that's all about the certificate of incorporation. That it establishes a body corporate. A body corporate. It establishes a body corporate. In short, an artificial person. Are you together? Yes. And one of the things that the examiner usually likes to examine is the content. Content or elements of certificate of incorporation. The examiner loves this question. The content or element of certificate of incorporation. In short, you are being asked, if you asked about the content or element, if you hold that certificate of incorporation of any company, what shall you see in all of them? What shall be the content of the elements that you shall see in all of them? You'll see the name, is it? You see the date of incorporation, unique identification number. If the company is limited or unlimited. If the company, if limited, is it limited by guarantee or limited by what? And also the date of incorporation. That's what we are going to write. Is that hard to understand? It's very easy to understand, is it? So number one, you say the name of the company. Of course, we must have the name of the company. The name of the company. The name of the company. Two, we must have something we call the unique identification number. Unique identification number. Unique identification number. Is it? The unique identification number. Is it called the BRC number? BRC. That is business registration number. I don't know, something like that. Then number three, the date of the company's incorporation. The date of the company's incorporation, the date. We really need to know when was this company incorporated. So we need to know the date in which the company was incorporated. Are you together? Then the next one is whether the company has limited or unlimited liability. 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 The next one, you have to know if limited now, is it limited by guarantee or limited by shares? So if limited, is it limited by shares or limited by guarantee? If limited, is it limited by shares or limited by guarantee? If limited, is it limited by shares or limited by guarantee? The next thing that we should know is whether the company is private or public company. 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 And lastly, what you shall see is the signature and seal of the registrar of the company. Signature and seal of the registrar of companies. Signature and seal of the registrar of the companies. Thank you, Raphael. That's true. That's true. Can see some people, Raphael and Mohammed, giving us some hint onto the same. Thank you for that. And so, yes, I have the answer. Somebody is asking, what is the difference between our limited by shares and limited by guarantee? We said that now. The difference between, one thing you should know is the difference between limited companies and unlimited companies. Unlimited means in case of any financial catastrophe, in such a situation whereby now your company is insolvent, the company is unable to meet its financial obligation, your personal properties, you as a member, your personal property can be used to cater for the company's financial situation. That is unlimited. But when we are talking about limited, there is some extent whereby we are having a cap, you see, or a gap, whereby now it's either limited by shares or limited by guarantee. Limited by shares means that your liability is limited to the amount of the shares unpaid for. Are we together? And limited by guarantee means that your liability is to the extent onto what you guaranteed or what you say that you shall contribute, like 1 million and so forth. Limited to the shares, we have said it's limited to the shares not yet paid or unpaid shares. In short, you can be having 1 million shares that you have subscribed, but you have already paid 800,000. So you are yet to pay the 200,000 shares, is it? So in the event of any financial catastrophe, they will take your 800,000 shares and they get, and if they will need even the other, you have to pay for this that you're yet. You see, that's the meaning. Right together. For the guarantee, these are the companies that do not operate with a share capital, and these are the companies, mostly they are non-profit making organizations, such as the NGOs, such as the charitable and clubs, like golf clubs, whereby they don't have a share capital. Whereby now the member now, like me, I say, for me, I will contribute 10 million. And then you say, to you, you shall contribute 12 million. In any situation whereby there shall be some financial catastrophe affecting the company. Understood? Thank you. So the next thing that we shall tackle is circumstances when certificate of incorporation can be withdrawn. Circumstances when the certificate of incorporation can be withdrawn. Circumstances when certificate of incorporation can be withdrawn, circumstances when the certificate of incorporation can be withdrawn. Somebody is asking a question here, Abel, that does the promoter needs to set aside the amount equivalent to the share value? You are asking about the duties of the promoter, that is Abel MRW. I will answer you very soon. We are going there. What if one paid all the shares? Is he not liable at all? His or her shares shall be taken, all of them. So, yes, he is liable because now his or her shares shall be taken, all of them. Let's talk about now. We have talked about the certificate of incorporation. When can it be withdrawn? Are we together? Withdrawing means you are given, but now it's now referred to as null and void. Are we together? Meaning, like for instance, if now we said that one way of lifting the veil of incorporation is through protection of revenue, you can remember last class, is it? Whereby now the company now it's used to evade tax. Even if now here you are evading tax, your certificate of incorporation can be withdrawn. 2, on the event of war, and then now the company becomes the enemy of the state, then the certificate of incorporation ought to be lifted. And also, what if that certificate of incorporation was obtained through fraudulent manner? You see, the certificate of incorporation have to be withdrawn. Have we understood that? That's right then. I've said circumstances when certificate of incorporation can be withdrawn is number 1, where the company to which the certificate has been issued turns out to be an enemy of the state. When the company to which the certificate has been issued turns out to be an enemy of the state. Where the company to which the certificate has been issued turns out to be an enemy of the state. Two, in case where it's discovered later, in case where it is discovered later, in case where it is discovered later, in case where it is discovered later, that the objective of the company are immoral, that the objective of the company are immoral, that the objective of the company are immoral. Are you together? 3, where the entity that was registered as a company is not a company in nature, that is, it's used to evade taxes. Where the entity that was registered as a company is not a company in nature, or it's a sham, it's used to evade taxes. It's used to evade taxes. Next one is if the certificate was obtained in a fraudulent manner. If the certificate was obtained in a fraudulent manner, if the certificate was obtained in a fraudulent manner, if the certificate was obtained in a fraudulent manner, if the certificate was obtained in a fraudulent manner, then it can be withdrawn. Yes. Let's talk of something else called, let me see whether certificate of trading. We are talking about the certificate of trading. And this is what we shall be talking about. And I think we have been communicating. If this is not your first class, you have heard me, or we have been discussing us. Here, we have been discussing about the certificate of trading. Am I right? So what's the certificate of trading? Yes. Yes. Certificate of trading. Or where have you come across it? Yes. Private companies. Thank you. People are leading, is it? Mapema ndio best. Ama ni aje? Ndio. So that's true. We said the differences between what? The public limited company as well as the what? The private limited company. Just a recap. Just a recap. Just a recap of the same. We said, number one, that upon incorporation, upon being issued the certificate of trade of incorporation, it must further go to the certificate of, to obtain the certificate of trading for it to commence business. This one, after obtaining the certificate of incorporation, would start the business. Directors, at least 2, here at least 1. Minimum amount of people here, they are 7. Here we have 1 with no maximum, whereby here we have 50. Is it to infinite? Is it? We also said fabrication. Mohammed, please could you let us capture the reason and tracing possible? Let us capture. Galaxy. What is Galaxy saying? So we are just recapping onto the same, the differences between the public limited company and the private company. The next one is here, you must publish your account. Here, no. Is it another difference? You must have a company secretary. Is it? Here, for a share capital more than 5, no, of equal or more than 5M, yes, among others. You can remember now. Now, this is a certificate of trading which is given by the public limited company. That even after obtaining the certificate of incorporation, it must further go and get what? Go and get, is our Muslim friends together with us? Huh? May I give them 5 minutes? Is it? If they are right, is it? Yes. Wanatuombea bana. Is it? And so we were talking about the certificate of incorporation, and we have said that it is issued to the public limited company for them to be duly considered to commence business and exercise their borrowing powers. Are you together? So for the public limited company, they cannot commence their business without having the certificate of trading. Are you together? Yes, because they are regarded as have jury, having the appropriate conditions for them to complete their business and exercise their borrowing powers. Are we together? Yes, let's write something about that certificate of trading. 3 sentences. We say a private company is entitled to commence. A private company is entitled to commence. Private company is entitled to commence. A private company is entitled to commence business at any time after incorporation. That is after issuance of certificate of incorporation. A private company is entitled to commence business at any time after incorporation. That is after being issued the certificate of incorporation. You say public companies require certificate of trading to commence business. Public companies can commence business or can only commence business after receiving the certificate of trading. I've said that public companies require certificate of trading to commence business. In short, it's a must. You can write it on your own English, is it? Yes. And it's a must. It's a must. So the last sentence is saying, a certificate of trading issued by the registrar certificate of trading issued by the registrar is a conclusive evidence, is a conclusive evidence that the public company is duly authorized to commence business, duly authorized, D-U-R-Y, is duly authorized to commence business and exercise borrowing powers. Can jump a line and say an NB there. You say any contract entered to by a company, any contract entered into by a company before it's entitled to commence business are provisional contracts. Any contract entered to by a company before it is entitled to commence business are provisional contracts. You see there, it is a criminal offense for a company. It's a criminal offense. You can ask him, where have I left it? Because if you take his book, you'll be too lost. If now he takes and then the next thing, all of us we are lost, is it? Where? Yes, a company. Yeah. Oh, for the public company. I've said for the point of public company that the public company requires a certificate of trading to commence business, which is a must. There is the word must. Yes, which is a must. Which is a must. Are you together? Yes. I've said we write an NB. We say that any contract entered to by a company before it is entitled to commence business are provisional contracts. Are you together? And we have said there down, you write number one. This one. Number one was, it is a criminal offense for a company to commence business before it is entitled to do so. It is a criminal offense for a company to commence business before it's entitled to do so. I'm hoping we are good. Abie. Two, number one, I've said it is a criminal offense for a company to commence business before it is entitled to do so. Two, every person in default is liable to a default fine. Every person in default is liable for a default fine. And last three, a company is liable. Company is liable to the court. A company is liable to the court if it fails to commence business. A company is liable to the court if it fails to commence business within a year of incorporation. Within a year or an year, within a year of incorporation, not an year, it is a year. Yes, that's the appropriate English, is it? Not an year. Huh? You are told that an is for vowels, is it? Yes, so it's a year. at least I used my fees appropriately there. So let's talk more about the promoter, is it? Because he is the person who is forming this company, formation of a company. Is it? Let's talk about this person. And we have said the person called a promoter is the person whom undertakes in the formation of a company, is it? Actually, sometimes the examiner likes to ask 2 marks, who is a promoter? 2 marks. You say the promoter is the person who undertakes in the formation of a company. You may add and also say that it follows it up until it commences, is it? But generally it's that the promoter is any person who undertakes in the formation of a company. I won't repeat that. So I will go to the next level called the legal position of a promoter. Of the legal position. Look, and I need you listen here because probably there shall be a question whereby you shall be asked about the legal position. If now the examiner asks you of any legal position of a person of an already existing company, right together, of an already existing company. Like for instance, the CEO or an employee or a CFO, right together, or a secretary, right together, or a director of a certain company, which is already in existence. The legal position, you should answer it this, that person is an agent, right together. That person is an agent. Number 2, that person is an officer, right together. That person is an officer. Number 3, that person is a servant, right together. That person is a servant. And last 3, that person is a trustee. Let me repeat again. But if the examiner asks you of a person whom is directly proportional to the company, which is already in existence, it already exists. The legal position of that person is an agent, an officer, a servant, as well as a trustee. Right together? Yes. But when we talk about the promoter, the legal position of a promoter in respect to the company that he is forming, the promoter is not an agent. He or she is not an officer, nor is he a servant, nor is he a trustee. Rest in peace, my English. I'm sorry. Kujana Mary. But in short, this person is not one of these. Right together. Right together. He's not an agent of that company. He's not an officer of that company. He's not a servant of that company. And he is as well not a trustee of that company. And why are we saying that this promoter is not one of these? It's because of this. Number 1, the company was not in existence. Is it? Because he's promoting it, he's forming it. It's yet to be operational. It's yet to be given this, the certificate of incorporation and the certificate. It's yet to commence. It's yet to be in existence. That's number 1. Number 2 is that the company did not set the promoter for it to be promoted. Right together. A promoter alijituma, is it? Right together. The company didn't set the promoter for its promotion. Right together. Then lastly, number 3 usually says that the company don't have a contractual capacity. Because we said that it's upon incorporation that's whereby now the company now have the contractual capacity. Is it? But now if it does not exist, then it cannot contract. It cannot have an agent. Is it? It's incapable. Is that understood? Yes? That's clear? Shall we write it or we should bypass it? I will give you by the end of this topic? We bypass it or we write it? Okay, thank you. So, you say, the promoter is not this. It's not an agent. It's not an officer. It's not a servant. It's not a trustee of the company he is promoting or to the company under formation. Said the promoter is not an agent, nor an officer, nor a servant, nor a trustee. The company he or she is promoting. This is because, number one, you say, the company was not in existence. The company was not in existence. Number two, the company did not ask them to promote it. The company did not ask them to promote it. The company did not ask them to promote it. The last three, the company does not have contractual capacity. The company does not have contractual capacity. The company does not have contractual capacity. And those are them. Right together. Yes. The company does not have contractual capacity. Number two, the company didn't set them to be promoted, and first, the company was not in existence. But now, in as much as we are saying that there is no relationship, that the promoter is not an agent, is not a trustee, is not an officer, is not a servant, there are some duties that the promoter ought to do. Is it? Duties of a promoter. There are some duties that you have to do. That the duties of a promoters are classified into two. The duties of a promoters are classified into two. The duties of a promoter are classified into two. That is number one, fiduciary duties. Number one, fiduciary duties. And number two, common law duties. Common law duties. That is general duties. General duties. When you're talking about the fiduciary, all what you're talking about is honesty. Are you together? All of what you're talking about is honesty. So, honesty, that act of being honest. We need a company promoter who is honest, is it? Not somebody who is fraudulent in a way, or somebody who is. So let's talk about the fiduciary duties of a promoter. Fiduciary duties of a promoter. In short, the thing that we shall be talking about here is all about the honesty. Together. And so number one is to act bona fide, to act bona fide. To act bona fide. Bona fide. What's bona fide? Yes? What's bona fide? For those who did business, yes? Thank you. Utmost good faith. Utmost good faith. Utmost good faith. Utmost good faith. That's the aspect of you being having utmost good faith. Then you have a duty of proper accounting. Proper accounting. Number three, we say disclosure of any personal interest. Disclosure of any personal interest. Any personal interest. Disclosure of any personal interest. Number four, you say they should not make secret profit. 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 Not make secret profit. Next, they should exercise care and skill. 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 When carrying out their duties, they should exercise care and skill when carrying out their duties. Number 6, you say, they must not act fraudulently or negligently. They must not act fraudulently or negligently. They should not act fraudulently or negligently. They should not act fraudulently or negligently in their performance of their duties. In the performance of their duties. In the performance of their duties. In the performance of their duties. Next one, you say, they should ensure that the prospector is not misleading. They should ensure that the prospector is not misleading. They should ensure that the prospector is not misleading. And those are the fiduciary duties. Fiduciary duties. The next thing that we can check is about the common law duties. Common law duties. Common law duties. In short, what you're talking about is the general duties. The general duties. In short, the common law duties are like, they are like the process of the forming a company, because it's according to the law, whereby he will reserve the name, assemble resources, you see, among others. Is it? Yes, they are more or less the same as the process of forming a company duties. So number one, the same, duty to determine and settle the company's name. Duty to determine and settle the company name. Duty to determine and settle the company's name. This one. Duty to determine and settle the company's name. He has also the duty to prepare and constitute the constitutive and other document necessary for incorporation. Duty to prepare the constitutive and other documents necessary for incorporation. We talked about them. They were 5. Is it? Yes. Next one is duty to register the company. 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 Next one, we have duty to secure the services of the directors. 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 Next one, duty to meet the preliminary expenses. Duty to meet the preliminary expenses. Next one is duty to prepare a prospectus. Duty to prepare a prospectus. Duty to prepare a prospectus. What's a prospectus? I believe most of you are working in a company. What's a prospectus? Yes. What's a prospectus? Yes. Yes, that's true. That's true. Watu wanaungua huku, wanawaka moto wa company road. So we are saying that the prospectus, actually, when we shall be defining the prospectus, we shall say that a prospectus is a prospectus or a notice or an advertisement that is inviting the members of the public to come and subscribe for the shares or to raise money, in short. So, yes, yes. That notice or that advert or that prospectus. You are right. That's good. Then next, duty to acquire assets for use by the company. Duty to acquire assets for use in the company. Duty to acquire assets for use in the company. Duty to acquire assets for use in the company. Duty to acquire assets for use in the company. Duty to acquire assets for use in the company. Next one, you have duty to enter into business transactions or contracts on behalf of the company. Duty to enter into business transactions or contracts on behalf of the company. Duty to enter into business transactions or contracts on behalf of the company. The last three, we have duty to ensure that the company under formation has an independent body. Duty to ensure that the company under formation has an independent body. As an independent body. I've said that duty to ensure that the company under formation is an independent body. In short, we are saying that you have a duty to ensure that this company that is being formed, that it is an independent body, that this company under formation is an independent body. And 23, we have some few minutes, so we can tackle something good. Let's talk about even the body is refusing for us to talk of anything else. Remuneration of a promoter. Remuneration of a promoter. Before then, or before we write something, let us discuss something about this. You know now that any form of salary is regarded as remuneration, is it? But in this relationship of the promoter versus this company that is being formed, the general rule is that the promoter ought not to be remunerated. Why? Why? Because of these three. I've said these three. This was not there. I say these three. Is it? These three conditions. But number one, the company was not in existence. Number two, the company didn't set the promoter for it to be promoted. Is it? And number three is that the company does not have a contractual capacity. So how can I pay you and I was not in existence? Is it? Are you together? But not with starting that rule, there are some acts of appreciation that usually are seen as if we are remunerating them. Are we understanding? Yes. And some of the issues include, for instance, they can be given the founders or management shares. Two, they can be given a lump sum upon their retirement. Right together. Three, they can be given some shares at a discount. Is it? Four, they can also sell their personal property at a profit, so long as they will. I'm saying that the fourth way they can be given, or they can sell their personal property at a profit to the company. Also, they can use their personal property to get a fully paid up shares, is it? Also, they can as well be appointed as the first directors of the company, is it? Also, they can do what? Another thing that you have ever heard of the promoters being remunerated. I've said 7. Another? Oh, can we write now? All these direct. We write. Okay, let's write then. You wish my command. Payment in form of salaries are known as remuneration. Payment in form of salary is known as remuneration. Payment in form of salary is known as remuneration. The general rule, the next sentence, the general rule is that the promoters ought not to be remunerated. The general rule is that the promoters ought not to be remunerated. This is because I've said the general rule is that the promoters ought not to be remunerated. Number one, say that the company was not in existence. This is because, number one, the company was not in existence. Number two is that the company did not ask them to promote it. The company did not ask them to promote it. The company did not ask them to promote it. The company did not ask them to promote it. The company did not ask them to promote it. Lastly, the company doesn't have the capacity to contract. 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 I don't know whether you shall write these. We are together. I don't know whether you shall write these, but you can jump a line and have almost a 2-sentence handwriting heading. You say, notwithstanding the above legal position, notwithstanding. It's one word, notwithstanding. In short, in as much as, or notwithstanding the above legal position, comma, notwithstanding the above legal position, a company may remunerate promoters. A company may remunerate promoters. A company may remunerate promoters in appreciation for their efforts or services, in appreciation of their efforts or services under the following ways. Under the following ways. I know you already know them, so you're just affirming whatever you have just discussed. Is it? You're just affirming whatever you have just discussed. So, number one, you say they can be given founders' shares. They can be given founders' shares, or management shares, or deferred shares, They can be given founder shares, or management shares, or deferred shares. Number two, you say they may be paid a lump sum amount upon retirement. They may be paid a lump sum amount upon retirement. They may be paid a lump sum amount upon retirement. They may be paid a lump sum amount upon retirement. They may be paid a lump sum amount upon retirement. Remember, they retire after the issuance of the certificate of incorporation for the LTD. But after they have been given, the certificate of incorporation for the LTD and PLC for the public, is it? They retire, they are duty, or they are no longer. You are discussing somewhere with another friend of mine that that he saw somebody who was told by his employer that the services are no longer needed. So in short, until when the services are no longer needed, that is when the company have been incorporated or it's have commenced business. Are you together? 3, they may be afforded. They may be afforded. They may be afforded the option to earn a commission, the option to earn a commission, the option to earn a commission, the option to earn a commission when they facilitate transactions between the company and third party. And it's like this, third party. They can be afforded the option to earn a commission when they facilitate transactions between the company and third parties upon disclosure. Facilitate transactions between company and third parties upon disclosure. Number 4, you say, they may be appointed as first directors of the company. They may be appointed as the first directors of the company. I've said about it. They may be appointed as the first directors of the company. They may be appointed as the first directors of the company. They may be appointed as the first directors of the company. Next one, number 5. By giving them an option to purchase a number of shares below the market price, by giving them an option to purchase a number of shares below the market price, that is at a discount. By giving them an option to purchase a number of shares below the market price, that is at a discount. By giving them an option to purchase a number of shares below market price, that is at a discount. Next one is by allowing them to sell their personal properties, by allowing them to purchase, by allowing them to sell their personal properties, by allowing them to purchase their personal properties at a profit, provided they disclose such profit, by allowing them to sell their personal properties at a profit, provided they disclose such profits, by allowing them to sell their personal properties at a profit, provided they disclose such profits, provided they disclose such profits. It's like, assuming this promoter have a lorry, that person have an FH of probably 12 M, you see, an FH or a lorry. And then that person bought it 2 years ago, and so it have depreciated. It's around 10 M. You see, the market value is 10 million. So the company may try to, one way of appreciating them, or buying this lorry probably at the initial amount of probably 12 million. So the 2 million difference, so long as the promoter is disclosing it, can be used as a form of appreciating them. Is it? Yes. The next one, you say, upon disclosure, upon disclosure, upon disclosure, upon disclosure, upon disclosure, promoters may be allowed to sell their personal properties. Upon disclosures, promoters may be allowed Upon disclosure, promoters may be allowed to sell their personal properties to the company in return for the fully paid shares. Upon disclosure, promoters may be allowed to sell their personal properties to the company in return for fully paid shares. In return of fully paid shares. In return of fully paid shares. In return of fully paid shares. Number 8 is that they can take fully or partly or partially. They can take fully or partly or partially paid up shares or debentures at a lower price. At a lower price as member or as creditor to be. They can take fully or partly or partially paid up shares or debentures at a lower price as members or as creditors. Any question? Any question? Anywhere that you're feeling that you are yet to understand, try to ask the question. Anywhere that you feel that when you go now alone, you see now you should at least remember at least how many percentage from this class. Yes? Yes? How many percentage? Yes? How many? Yes? Leaders. You know you are the leaders here. So I say you should just say 95, 80, 50, 40. How many? Yes? 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 80. 80%. How many? 70. 25. How many? 40. That 70, 40, 50, 48, 40, 43, 52, 70, 40, 50. Have I asked you? Yes. That. Whom have I not asked? Yours was 70. Oh, thank you. Wow. So may you remember even more than that you have just said, that it's Regime 50, is it? Yes. So that's the end of formation of companies for our today's class.